Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. My pleasure to serve as coordinator for today's program, which focuses on employee health-related issues and includes things like drug testing, accommodations under the ADA, and medical leaves, among other related topics. Joining us today, and we're fortunate to have both of them, are two members of our Labor and Employment Practice Group, Courtney Nichols and Shanel Thomas. Both of them are in our Bloomfield Hills office. Before we get started, I'd like to take a few moments to provide you with some background about today's speakers and about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 130 attorneys. We have 7 offices in Michigan, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's employment law practice group includes more than 20 attorneys who work in the areas of traditional labor law, human resources consulting, investigations, and employment litigation. Today's webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute and 1.25 professional development credits through SHRM. Following today's program, a certificate of completion will be emailed to each of you reflecting this credit. If you don't need CE credit, you can just disregard that email. Now, just a bit of background about our presenters today. For nearly 15 years now, Courtney Nichols has exclusively defended employers in litigation, and she provides advice to them on all aspects of employment law, including pre-litigation compliance with the ADA, FMLA, and the Fair Labor Standards Act. A member of our Bloomfield Hills office, she also assists clients with drafting and enforcing contracts, including covenants not to compete and executive severance agreements. Shanel Thomas also practices in Bloomfield Hills, and she's a member of our employment law practice group as well. Shanel represents employers directly and through their LPL insurance providers to defend in litigation ranging in a number of areas, including claims of alleged sex and age discrimination, wage and hour disputes, harassment and violations of the FMLA and ADA. Now, just a couple of housekeeping notes and we'll get started. For the Q&A portion of our webinar, we're going to use our questions window on your GoToWebinar navigation display. Please take a moment now to locate that window and feel free to enter questions as they occur to you during the program. At the end of the presentation, we're going to try to answer as many questions as possible. And I always like to add one caveat, that being to please ask questions of a general nature. Discussing specifics or ongoing issues in your particular workplace is best done privately, as I'm sure you will agree. Finally, I want to mention that today's session is being recorded, and that recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share that link or direct your colleagues to that page. Thanks again for attending today's webinar. Now let's get started, and Courtney, I believe you're up first, so please take it away.
Sounds great. Thank you, John, and thank you everybody for joining us today. We wanted to check in somewhat early in the year to do what we've called an HR health check, which is to sort of recap some of the most critical laws that we see employers continue to struggle with, and to identify trends and hopefully some best practices to keep everybody out of a courtroom and away from governmental audits and charges of discrimination. So with that said, one of the first things that we're going to discuss is what I believe to be still the thorn in many of our sides, which is the Family Medical Leave Act and dealing with medical leaves under both the FMLA and the Americans with Disabilities Act. So I know that many of you on this call are extremely sophisticated and deal with the FMLA and know what these regulations say and are familiar with some of the requirements. So I'm just going to go through these at somewhat of a high level, but while we do it, I'll talk about what I am seeing in my practice as being some of the biggest missteps that employers are taking. So again, just very basic refresher. The FMLA obligates covered employers to provide up to 12 weeks of unpaid and job protected leave per year for eligible employees to take time off for the birth or care of a newborn child or with placement after an adoption or foster situation, for the serious health condition of an immediate family member, or for their own serious health condition. So when you look at the FMLA, generally those are going to be the most common reasons, the medical-based reasons, medical for you, medical for your child, or somebody that is meeting the definition under the Act, or a birth or placement issue. However, there are also some leaves for FMLA, reasons for FMLA that aren't as ubiquitous, qualifying reason related to military status or to care for a covered service member. So again, just a reminder, I think a lot of times we assume that the FMLA means something very specific and it relates only to medical, but there's also some military connotations that can come into play. So when we look at the eligibility requirements, one of the things I wanted to stress today is that this is not an area where there's a lot of nuance. So in many of our employment laws, we live in shades of gray, which means that it's not a clear-cut answer as to whether something's an undue hardship, as Shanel will touch on, or whether something is pervasive when you're looking at a harassment claim. These are things that are clear-cut. So to take FMLA, an employee must work at least 12 months or have the covered period of time when you look at breaks of service. They must have worked 1,250 hours over the past 12 months. If the employee worked 1,248 hours, then they are not eligible for FMLA, and you have no obligation to provide that leave. We have won cases where somebody worked 1,235, 1,240. So again, it might seem like this is something that is arbitrary and subject to change. It's not. So I always encourage my clients, if you have a situation with FMLA, make sure that you're actually dealing with an eligible employee, because that could be a very, very easy defense. And usually when we have eligibility questions, it's with either part-time employees or it's with employees who have used FMLA previously, such that during the applicable calendar benefit year that the employer is using, the individual is not eligible. So just things to keep in mind. Also, whether your company falls under the definition of a covered employer because they have enough employees. So the third bullet point is, this employee must be working at a location where the company employs 50 or more employees within 75 miles. Again, this seems like something that we can all sort of understand intuitively. Do we have that many employees on our payroll register? What I would tell everybody is that where I'm seeing issues with that bullet point is in joint employer scenarios. So the Department of Labor and even the administration coming from our state government and from Attorney General Dana Nessel is really coming down on joint employment situations. So if you're a staffing company, if you work with staffing companies or staffing agencies, if you have a parent company and there's a number of subsidiaries under the same parent, and there could be employees shuffling back and forth, working for multiple different entities, the fact that you have a different EIN does not necessarily mean that you are going to be singularly viewed as a sole employer and only 50 people on that EIN are going to be counted. If there's a joint employment situation, they will aggregate the employees to see if you're over that threshold. So just something to keep in mind, that is a trap that I have seen people unfortunately fall into, even if they are very up to speed on the FMLA, by just assuming, that's our sister entity, we have no relationship to it other than having a same parent, so there's no way they could ever find us to be jointly employing these individuals for purposes of FMLA coverage. If you have a question or concern, I would strongly urge you to get that reviewed before reaching that conclusion, because it's not always as simple as it might seem. So continuing on, after we assess, is this employee eligible? Are we eligible? Again, this gets to the covered employer section. Just consider that there are no easy outs for public agencies, for educational agencies, that there's going to be coverage from that arena as well. So the first one, again, on this slide, when you look at the first indented bullet point, that's where you really need to make sure that we've done the correct analysis, we've looked at the right amount of work weeks, and that we're making sure to address any joint employer situation. So we've made sure we're covered or not covered by the FMLA. we've made sure the employee is eligible or not eligible from the FMLA. Now, what's the situation? So again, I know many of you are extremely familiar with this, but there are two types really of FMLA leave. You have continuous leave, or when employees take it in a block of time, 1 week, 2 weeks, 6 weeks, 12 weeks in one fell swoop, or you have intermittent or reduced schedule leave. I very rarely have clients that call me with concerns about continuous leave or about employees that are taking a specific block of leave. Almost always, when we have concerns about the FMLA or charges filed with the Department of Labor or complaints filed with the federal court, they are involving allegations of intermittent leave, denial, abuse, or retaliation. Okay, so with intermittent or reduced schedule leave, this is an explicit rule within the regulations that employees have the right to take leave when medically necessary in separate blocks of time, or by virtue of reducing a schedule from 5 days to 3 days, from 10 hours a day to 7 hours a day, etc. So that is something to really think about. The only exception is pretty rare and doesn't often come up, but that's relative to the bonding with a newborn child or a newly placed schedule, or with a newly placed child. The employer can deny that request, or it can be agreed upon. With other forms of intermittent leave, the employer doesn't have the ability to just say, like, no, that's an undue burden. So keep this in mind. Again, with the FMLA, it's different than the ADA, in which Shanel's going to cover. We don't get to say you working that reduced schedule is an undue burden or a hardship on us. You have to provide it, assuming that the certification, the eligibility, all of those things have been met until that time is exhausted. So the key with FMLA is that it's job protected and unpaid. So this is very different than an accommodation under the ADA. An ADA accommodation, again, not to trample over what Shanel's going to be covering, but that can vary from a standing desk to leave in certain circumstances. FMLA is leave, period, unpaid leave, period. Okay, so it is not, for example, allowing somebody to work remotely. That would be an accommodation. So it is unpaid leave that enables somebody to come back to their job or a substantial equivalent, and that is what the statute says. So I often draft FMLA policies, and one of the first questions that I ask my clients when we're drafting those is, do you require them to exhaust paid leave benefits or PTO while on FMLA? You have an absolute right to have those run concurrently. So for example, if somebody has 2 weeks of paid vacation and they take 12 weeks of FMLA, they're paid for 2 and the remaining 10 are unpaid and they return with no vacation. That is 100% legal and something that employers have the discretion to implement. If you are unsure of what your company does or should do, I would tell you, you want to make sure that you have a written policy and you're enforcing that consistently. The policy needs to explain what happens with paid leave benefits when somebody is on FMLA. You should also have some understanding as to how that works with short-term disability or long-term disability. An issue I see employers make is that they will put somebody out on short-term or long-term disability and they do not start the FMLA clock. When somebody is out for a serious health condition, or if they're taking intermittent leave, and we know it's for an FMLA covered reason, then you need to make sure that administratively that time is being counted and that the employee is aware that that time is being counted as FMLA. Because again, we're talking about a defined period of leave that's available, and once it's gone for that benefit year. So if we don't count it, and if we're not applying it, somebody could be on short-term disability for 30 days, they could be on long-term disability for 3 months, and if you haven't designated it as FMLA or gone through that process, they could then say at the conclusion of that 4-month period, now I would like to be on FMLA leave. So just something to think about when we're looking at it. In terms of the job protection component, one is very simple. Somebody goes on FMLA, say they have a baby, they come back to the job that they have, same pay, same benefits, etc. An issue that I will see is when somebody's gone. Generally, this happens with a continuous block of leave, and while that individual is gone, we find that there's a worker who's doing better on that specific shift or who works better with a specific team. So there's a desire to change shifts, to change teams, to reschedule. That is going to be a problem. Okay, so we really need to make sure that they are returning to their exact job or an equivalent job, same shift, same benefits, etc. And if there's, again, a desire to do something different, you should be seeking consultation with counsel and make sure that that's all flushed out before the individual comes back. In terms of the last statement on this slide, which is denying a bonus for which the employee qualified prior to the FMLA, again, if this is a situation where an employee has accrued and earned a bonus and then goes on leave, making the argument, for example, well, you weren't here when the bonus was paid out, is not going to work. That is going to be deemed accrued and earned time, and pay, it must be paid. So just keep that in mind. That is different than other types of bonus programs that might be dependent on selling a certain amount or meeting certain criteria. You might have options relative to those bonuses. That doesn't mean you have options relative to discipline for the FMLA protected leave. But if there's a question or a concern, you want to really make sure that it's reviewed, because there is definitely nuance there, and that is an area that will get you into some trouble. So you understand, what your obligations are relative to job protection and the FMLA, and then we throw another wrench into it. So it seems like everybody is pretty comfortable with, okay, I get the FMLA and I know that we have PTO and that's unpaid. So, the obligations there are relatively limited. We can deal with the FMLA. And then you hear about the Michigan Paid Medical Leave Act. And to make it worse, this has been, I don't know how to describe it, a yo-yo. There's been ups, there's been downs. It's been all over the place, and it continues to be all over the place. But if you were participating in these webinars, I would say maybe 18 months ago, last summer, so the summer of 2022, you probably were panicked, because at that time, there had been a decision that said that what happened with the PMLA was not appropriate and was going to be reversed. So taking a step further back, right, the Paid Medical Leave Act was a ballot proposal. So it was something that was a citizen-led initiative that was going to hit the ballot. And before it hit the ballot, the Michigan government at the time, the state government, enacted it as a law, which gave it the right to then amend it by a simple majority. And the majority of the government at that time was Republican-led. So the Republican-led majority amended the proposal during a lame duck session to dramatically modify it, okay? And it made it far more what is called business friendly, okay? There were a lot of exceptions. It's pretty limited. If you have PTO, you can use that. We'll get into those specifics, but that's what happened. So that's what became law. Then that obviously was challenged. People did not like that, or like the concept that that was even a possibility, that these things could happen. And so as of 2022, there was some panic about, oh no, this could go back to the way it was written in the ballot proposal, which is, it has extreme ramifications for employers. So that was challenged to the Court of Appeals. And about a year ago, in January of 2023, the Court of Appeals said, no, that the amended versions of both the PMLA and the Michigan Improved Workforce Opportunity Wage Act were valid and enforceable. So that is what is currently in place, okay? So we go back to the amended law that always was, that's pretty flexible, pretty employee friendly. I've not seen a single claim alleging a PMLA violation. But that decision of the Court of Appeals was subsequently challenged, and we're right back at it. So there was oral argument in December on this topic. So I would expect an opinion from the Michigan Supreme Court probably by the end of this quarter or summer of 2024. So of course, we will let you all know what happens. If it's affirmed, then we just continue as we always have been. In my opinion, this is a relatively easy law to apply, and again, very limited exposure. But let's talk about some of the specifics just in case we're dealing with the reversal, and to make sure that everybody's up to speed on the PMLA. So as it exists right now, it's going to apply to employers with 50 or more employees, okay? So it does not apply to what's considered small employers. It does not apply to the US government, other states, or political subdivisions of other states. So that's different than the FMLA. Again, the goal here was to make it a pretty small statute in scope. So outside of covered employers being, a relatively decent definition for businesses, there are a lot of exemptions as it relates to who is even entitled to paid medical leave. Okay, so anybody who is exempt from receiving overtime under the Fair Labor Standards Act is not entitled to paid medical leave. Independent contractors, not entitled to paid medical leave. Anybody covered by a collective bargaining agreement, not entitled to paid medical leave. And likewise, government employees, not entitled to paid medical leave. Okay, so that's really critical. When you look at individuals who are not in the state, not entitled to paid medical leave, variable hour employees or seasonal employees, not entitled to paid medical leave. So you really have a wide swath of individuals who are just not going to get this benefit. It's not going to even be applicable to their employment. In terms of the problems that I see in my practice, almost always it's questions about leave and accrual. So for everybody that is eligible, so you take out everybody who's exempt, generally you're going to be looking at non-exempt full-time employees who are not in a union are the ones who are eligible for paid medical leave, okay? But the third bullet point is one of the, I think, the big things, which is 40 hours, okay? So can be capped at 40 hours per benefit year. So this is, there are accruals. There are all sorts of ways that you can add this. If you do an accrual, you stop after 40 hours. If you front load, you stop after 40 hours. They're only entitled to receive it, to use it after 90 days of employment. And you don't have to restore previous balances to individuals who left and then come back to the company. Beyond sort of the basic accrual and total capacity rules, you also have permitted uses. So pretty straightforward. The first one I would just characterize as being sick. The second one, it relates to domestic violence or sexual assault, right? If the employee or has a family member that is the victim of those actions, they can use it. Closure of employee's place of business. Now, this is kind of, I don't know if ironic is the appropriate word, but maybe bizarre, which is this language existed before COVID. So, and obviously we know how that happened after COVID, but if something is shut down due to a public health emergency, then PMLA can be used for that. More reasons for PMLA are outlined in the statute, and there are fact sheets on that. You can require advance notice. You don't have to pay it out. If somebody is using it, you want to keep those records for 1 year. Generally, you want to keep almost all employment records for a minimum of 3 years. So I would never recommend any type of destruction policy that is getting rid of documents regarding usage of paid medical leave within a year in any event. And then you can require leave either in 1 hour increments or whatever the smallest block of time that you let somebody use leave for, as outlined in your employee handbook. So if the Michigan Supreme Court reverses the appellate court, the law would revert. Okay, so as I mentioned, this is going to be a dramatic change. So this would take it from only eligible full-time employees that are working a minimum number of hours a year to everybody is entitled to use at least 1 hour of paid medical leave for every 30 hours worked, up to 72 hours per year. Okay, so this is a massive change. And it also is applying to small businesses, even if you have less than 10 employees, although it's a smaller cap. You'd have to go up to 40 hours of paid leave and 32 hours of unpaid leave. So dramatic difference just regarding the scope and the cost to all employers if this is reversed. In addition, right now, the most important thing about the PMLA is that if you offer 40 hours of paid time for any reason, paid sick time, paid vacation, etc., and you have a little clause in your handbook saying you can use your vacation for any reason under the PMLA, or you can use your PTO for any reason under the PMLA, then you do not have to offer 40 hours of PTO, 40 hours of vacation, plus 40 hours of PMLA. So if somebody, for example, has a 40-hour block of time and it's front loaded, so starting January 1st, they get 40 hours to use for whatever they want, and your handbook says that could be inclusive of PMLA, and they decide to go to Florida from January 23rd to January 30th, they come back, they get sick in February, and they say, I'd like to use paid medical leave because I'm sick. The answer is no, right? That time has been exhausted. And employees will push back on this There are fact sheets that the state of Michigan have published. There's articles, there's lots of ways that we can explain to them that that's not the way it works. And I, of course, recommend that that be flushed out in a handbook so that you're sort of trying to cut off some of those questions at the pass. The problem, if this law is reversed, is that now you cannot do that. Okay, so you're dealing with whatever you offer in PTO plus 72 hours for the vast majority of employers of paid PMLA. In addition, you're going down to 6-minute increments, which we all know what that means. People are going to be leaving early, they're going to be coming late, they're going to be taking long breaks, and they're going to be trying to attribute it to sickness that qualifies under the PMLA. So I don't want to panic anybody. It's really hard, in my opinion, to predict what this particular Supreme Court is going to do. It has gotten what we would consider to be more liberal, setting aside any political commentary, just looking at who has been appointed and by what governors. It has become a more liberal court in most recent years. So that would tend to weigh in favor of a potential reversal of the Court of Appeals. But we are trying to get a read on it. And of course, as soon as we know what's going on, we will have an update on this topic. If there is no change and the reversal is affirmed, there will be nothing for you to do. If there is a change, then there will be a new effective date, right? The Supreme Court will almost assuredly say, employers have this period of time to comply with the provisions of the ballot proposal. And then there should be some significant policy revisions. So that's where we're at relative to the PMLA and the FMLA. Some trends that I want to touch on as we head into 2024. Under the FMLA, there are certain things that we've seen, especially specifically with intermittent leave for a long time, conditions related to chronic pain, back pain. There are a lot of FMLA cases involving IBS and other conditions where you can't necessarily predict when they're going to happen, how they're going to flare up, what type of symptoms they're going to cause. What we're seeing now is a lot of mental health diagnoses that are leading to intermittent FMLA. And I have had calls from people who ask me, are these conditions, is somebody, writing in from their therapist saying they need this, is this covered under the FMLA? And the short answer is yes, so long as the certification of healthcare form is properly filled out. We're entitled to the information on that form and not to go beyond it. You can get clarification regarding ambiguities or vague responses, but if a healthcare provider is completing a certification form and is completing the sections and the information is straightforward and responsive, then mental health conditions are going to qualify. And I almost always see them in terms of intermittent leave where somebody's gone, from 1 to 2 days per flare up, 2 to 3 times per week. And so that's confusing because does that mean that they're going to be gone 1 to 2 days a week? Does it mean they're going to be gone the entire week? Again, with the intermittent FMLA, our hands are proverbially tied. There's ways that you can seek clarification if there's something that is inconsistent in that form. But the problem with these mental health conditions and being empathetic to the individuals that have them is that you cannot say, oh yeah, when this person has a bout of depression, they're gonna be feeling better within 12 hours and will be back to work. So the courts and the EEOC and Department of Labor, when they look at these type of conditions, I think one of the things to keep in mind is that we have to be empathetic and understanding and realize that this is not something that we're going to be able to put into a very simple box and deal with and schedule in a way that might lead to efficient business operations. So please note that, just dealing with that is something that we continue to work through. And if you have questions about certification forms or how this works, or, if somebody's a key employee and we're dealing with reinstatement after a mental health leave, these are all things that you should be seeking counsel and guidance on because they can become very complicated very quickly. So beyond the mental health trend, we have a lot of cases with FMLA where somebody has workers' comp and then they come back and they're on FMLA, or they're on short-term disability or long-term disability FMLA, like I mentioned, at some point in that mix. It's important to understand that these are all different processes. Long-term disability, short-term disability are insurance-based programs that provide wage loss benefits. FMLA provides leave. Workers' comp can provide wage loss or require certain type of modifications depending on work-related incidents. So try to keep them separate to the extent possible and understand that many times there's going to be overlap, which will require 3, sometimes 4 different analyses. Beyond those trends that we see, moving on to our next slide, caring for a loved one is becoming, a topic that's important, and especially what we're seeing too is a trend towards fathers, trying to assert more rights relative to caring for children and for parental leave. So there's no parental leave policy in the state of Michigan yet. I would bet you within the next 5 years there will be. So you can all take me at this, and we can be back here in 2029 seeing if I'm right, but I would bet there will be. So just something to keep in mind. Again, I think a lot of this content on this slide just deals with being empathetic. There's a real push towards understanding, our employees are human beings, not robots, and have needs that go beyond the 4 corners of the wall of the workplace, while also trying to balance the fact that we all do have production and efficiency standards to be dealing with. So things to keep an eye on as we move on. With that, going to our next slide, I'm going to hand it over to Shanel to bring people up to date on what we're seeing with the ADA and provide a refresher in that regard.
Thanks, Courtney. Good afternoon, everyone. So the American Disability Act, or the ADA as we'll refer to it, as a lot of you probably already know and are familiar with, this act makes it unlawful to discriminate in the employment context against a qualified individual with a disability. And that qualified portion is going to be really important in our discussion, and we'll go through that in a little bit more detail in a second. But under the ADA, a qualified individual is someone who meets the skill, experience, and education, or whatever other requirements of a specific job position. And the most important part, perhaps, is that this individual is someone who can perform the essential functions of the position with or without a reasonable accommodation. So in short, the act is going to require employers to provide reasonable accommodations to help individuals perform essential job functions. It obviously prohibits discrimination, and the long and short of it is that employers should not prejudge the abilities of people with disabilities. This act actually specifically requires employers to go through and individually assess an individual's abilities based on both the essential functions of the job and then what, if any, potential reasonable accommodations would help them or enable them to overcome the job-related barriers. And along the same lines, the ADA requires employers, like we already said, not to discriminate, of course. Also, employers cannot make medical inquiries except in limited circumstances. And those circumstances are going to be things like pre-employment. So employers, you can ask a potential applicant questions about their ability to perform job-related functions, right? It's no issue with doing that. But you have to be very careful that the questions that you ask are not phrased in terms of a disability. You can also ask after a job offer is made, but before the person actually starts working, you can require that they take a medical exam, but only if everyone who will be working in that exact job function must also take the examination, right? So you can't require somebody to go and take an exam and then they start working and they find out that none of their coworkers have had to do this. And even if they don't find out, you still can't do it. Another example or exception rather of when you can make a medical inquiry is if it's related to the job and is consistent with the business. So you've hired the applicant already, they've started working, you can't require them to take a medical exam and you can't ask them questions about the disability unless you can show that the questions are job related and they're necessary for your business to be conducted. Another example of when you can ask medical questions, you can conduct a voluntary medical exam if they're a part of the employee's health program. Another requirement, just going down the list here, is that you have to keep medical information confidential. As many of you know, what's important to note here is that this medical information, keeping it confidential, just a tidbit here, that also includes personnel file records. So for whatever reason, when you are asked for an employee's personnel file, you have to make sure that that does not include their medical records. Those records need to either be excluded or fully redacted. So that's just something, generally speaking, to keep in mind. And then again, you must accommodate. So there are the most common types of ADA cases that we see, especially now, is either there's a case where an employee is alleging that they've been wrongfully terminated, or they were issued some type of adverse employment action. And typically this is because of either a medical condition, because of their performance related to a medical condition. It can be based on the employer's fear or supervisor or manager's fear of behavior that's associated with a specific condition. And that's a tricky one, because even if the employee has not shown behaviors associated with that condition or whatever medication they may be taking, if comments are made such as, oh, they're crazy, or wow, it must be a psycho. And I know you hear these things and you're like, who would ever say that? But trust in me, you'll be very surprised. Even words like, or things like crippled. These are things that we frequently see lead to litigation. There are, or an employee receives negative treatment after they learn of the medical condition. So everything was fine, they were performing their job well, and then they told them about this medical condition, and suddenly they claim that they received negative treatment. So in cases like this, the merits will usually turn on, first, of course, whether the individual was qualified. So again, could this employee perform the essential job functions, and then could they perform those with or without the reasonable accommodation? The second merit is going to be whether the employer had knowledge, right? And that's kind of just a common sense thing, because although we see it all the time, you can't say that somebody discriminated against you for something that they did not know. And a lot of people have medical conditions that they're not physically visible. So that's where knowledge is going to be really critical, if you have a condition that you can't see and they would have had no knowledge of. And then also whether the employer had a legitimate reason for whatever employment action they took. So a good example of this is an employee who was always late. They had very poor attendance record, and then they had a record of poor performance even when they did finally come into work. So, and all of that should be very well documented. And then, it comes out that they had some type of a disability or a condition. Okay, well, if they were subsequently terminated or suspended or whatever, then that employer is likely going to be able to show, well, we had a legitimate reason. We didn't know anything about the disability. What we did know is that this employee was always late, didn't like to come to work, didn't perform well. So the merits will turn on that as well. And then just some more typical scenarios that we often see for litigation purposes is that, of course, an employee's requested accommodation is denied, right? So they're going to say, hey, I asked for this stool because I can't stand for longer than an hour. They said no. Or the employee quits or is constructively discharged because of the medical condition, or the employer didn't provide more FMLA more leave after their FMLA ended. And in these cases, the court is going to look at whether or not there was an interactive dialogue. So what employers are going to want to make sure is, once you know that someone has a disability, This interactive dialogue, it is very fact heavy, and it will vary for each case, but they're going to be looking at discussions that the employee and the employer had. You know, did you guys discuss the disability? Did you discuss the accommodation requested? Have you actually examined the reasonability of the accommodation requested? Or did you just say, no, we can't do that. We can't make that work. And here, the employer's defenses will include undue hardship. And it's really important to remember that undue hardship is not the easiest thing to prove. Employers should really keep in mind, a lot of more than half, it's reported, more than half of accommodations for people with disabilities actually cost employers nothing. For those accommodations that do cost the employer something, the average cost is about $500. So it is pretty difficult to show that an accommodation will actually cause the employer undue hardship. So don't bank on that. It's not a, oh, that's just too difficult. It's not a matter of inconvenience. It's not a matter of you know, I don't think that we can do that right now. It's really not optional. It has to be a pretty hard or expensive. It has to be, hardship is a proper term for it, and it's not, again, it's very difficult to show that. And then again, we have most of the common mistakes that we see under the ADA. The most common is going to be that first one. So failing to provide accommodation language, both in the handbook and the application. That makes it, you know, a lot easier for the employee in litigation. Failing to provide training to supervisors. So again, when we're talking about different comments, different language that can be used during the course of employment, that gives the employee the ability to say, hey, well, they said this, or maybe the supervisor doesn't know that they have the obligation to provide these reasonable accommodations. So they have an employee that is disabled and they ask them again for that stool because they can't stand up, and they don't know that they actually likely do have an obligation to provide that reasonable accommodation. And then the most common would probably be losing the employee on leave. So that's the situation where the person is disabled, they're on FMLA or another type of leave, and then you end up not, you know, being able to contact them, or you fail to contact them, you fail to stay updated with the status of their leave, the status of their disability, you know, and what you can do to help accommodate them. So we have the ADA questionnaire, and here documentation is going to be really, really important when it comes to the ADA, and documentation is absolutely necessary when the employee's disability or need for accommodation is not known and not obvious. So under the ADA, there is what's called an interactive process. And the trigger for this process, or when the process begins, is going to be as soon as the employer becomes aware that the employee may have an impairment that limits their ability to perform their job. So as soon as that person tells you, as soon as you see, as soon as they have that conversation with you, that is the beginning point of the interactive process. And from that time that you become aware of this impairment, that is when the process starts, and that is when you need to get your documentation together. So the ADA questionnaire, of course, what type of medical documentation is required will depend on the situation and how much information you already know about, again, the impairment, the limitations, and the need for accommodation. So whether or not you need just one form, you know, kind of confirming what you already know, or whether you need a full medical record regarding the specific disability, because you know absolutely nothing about it. And on the next slide, we have some more information about this questionnaire. So what's important for employers to remember is that you can't ask for unrelated information. So you can't, when you say, well, I don't know anything about this disability, I need your medical records. Well, you can't ask for all of their medical records. You can't ask for everything from the broken ankle they had when they were 10 up until present day. It's going to be really important that the medical documentation that is provided or requested is related to that specific disability. And that medical documentation should describe the nature of the impairment, the severity of the impairment, the duration, how long have you had it, how long is it anticipated that it will continue on, the specific activity or activities that the impairment will limit, and then the extent to which the impairment will limit this employee's ability to perform their activity. So essentially, the medical documentation needs to tell that story, right? It needs to say, okay, what are we dealing with? How bad is it? What do you need? You should be able to, in the future, you should be able to go back to this medical documentation and very clearly and vividly see exactly what is needed. So just some reminders here. Employers aren't obligated to grant the reasonable accommodation that the employee prefers if another one exists. Okay, so we're not going to play the, oh, well, I got approved for a reasonable accommodation. Well, this is what I want. If there's something that another reasonable accommodation that exists and is better suited, and it would propose less of a hardship on the employer, then they have the right to grant that reasonable accommodation. The employee's preference does not necessarily matter here. Again, it's a lot easier to prove that the employee is not qualified because, as Courtney mentioned, if they're not qualified, the discussion stops there. If they're not able to perform the essential job function without the accommodation, then again, the conversation stops there. So to the extent possible that you can show that the employee is not qualified, that's what you want to do, because it's going to be a lot easier to show that they're not qualified than to show that there's an undue burden. That's not going to be easy. And then here, a lot of times we'll have employers that say, well, if this person needs extended leaves or they have to take frequent breaks, let's say that's their reasonable accommodation, then soon we're going to have other employees that's going to need the same thing. And before you know it, we're not going to have anybody on the floor performing the work. And that's what we call the slippery slope concern. And what's just really, really, really important here is that the EEOC really does not care about what could happen as a result of these reasonable accommodations. You really have to be able to show that this has already happened, right? We're already seeing, you have to show well-documented metrics of how granting this reasonable accommodation has negatively impacted your business. And just simply saying, well, if I do it for them, I'm going to have to do it for everybody. Well, that hasn't happened. Everybody hasn't left the floor. And the courts nor the EEOC, they just actually don't care about that slippery slope. And in fact, they use it against employers in a lot of cases. So just be very, very careful of that. This is going to be very fact intensive and made on a case by case basis. And I think the next two slides discuss what to expect in 2024. And essentially the EEOC, they come up with regulations and they come up with their strategic enforcement plan, and it covers 4 years. So right now we're looking at from 2024 all the way up to 2028. And they've explicitly stated in there that they plan on increasing the scrutiny for point-based attendance policies. So what they're looking at there is that if you have a point-based attendance policy and it fails to account for employees who require accommodations, that you can forget about it. That is explicitly what they're looking for. So, and what's going to be really important here is when we're thinking about employment discrimination regarding, let's say, long COVID, or things like that. We're really starting to see a lot of litigation regarding that. So you're going to want to make sure that if you have a point-based attendance policy, then that needs to take into account if you have employees that have qualified disabilities and who require accommodations. And you need to make sure that language is explicitly provided in your policy. And then just same thing here, over the past year, we've seen a 70% increase in ADA litigation. So over the next 4 years, considering that they've put a higher emphasis and increased the level of scrutiny on these cases, we expect that number to go up. So it's not going to get easier for employers. Actually, we expect it to get a little bit more challenging over the next 4 years.
All right, so now that we've talked about some of the ADA and FMLA issues, just a few things that I want to touch on before we conclude with the discussion of the Pregnant Workers Fairness Act are some questions that we get a lot about pre-employment drug testing and drug testing in general, especially with recreational marijuana being legalized in the state of Michigan. So under the ADA, you can certainly have drug-free work policies that prohibit the use of illegal drugs and alcohol at the workplace, make sure that people are not coming to work under the influence or impaired. If you're a federal contractor, obviously there are even more heightened standards. You have to comply with the Drug-Free Workplace Act. And of course, you can always require employees to meet the same standards of performance and conduct as other employees, even, for example, if they had or disclosed a prior drug problem. Now, touching on these things a little bit, the last one, okay, so when we talk about require employees who use drugs or alcohol to meet the same standards, that does not mean if somebody comes in and says, listen, I'm an alcoholic and I need to go to treatment, you can say, well, we have an attendance policy, you've exhausted your PTO, you're out of luck, okay? I think most people on the call know this, but a disclosed condition like that is going to necessitate leave either under the ADA or the FMLA if eligible and covered. The difference is, so you have, Tom who comes to you and says, I need a couple of weeks off because I have to get treatment, and is approved and gets a couple of weeks. That's very different than Tom does not show up to work for 5 days. And then when you meet to terminate Tom's employment, he says, oh, and by the way, I was on a bender because I have an alcohol problem, and so I need leave to deal with that. It does not immunize conduct, but it may obligate you to provide an accommodation. Moving on to the next slide. So when you look at alcohol and drugs, again, the circumstances may vary. If you have somebody that you suspect to be an alcoholic, just requiring constant breathalyzers is going to be problematic. There can be random drug testing. Companies can implement that. I will tell you, as a practical matter, okay, I find that most of my clients have either removed a lot of their random drug testing policies altogether, or they have removed testing for marijuana at all, unless they're a federal contractor or it's a DOT or safety sensitive job. Because while we thought random drug tests were a great way to deal with problem issues 10 years ago, now a lot of my clients say if we random drug tested this business, we would lose half of our employees because they're going to test positive for THC. So just something to think about. Also, a legal drug, when we talk about federal laws, marijuana is still considered an illegal drug. It's still a controlled substance. So, when we talk about the ADA, it provides protections, and as we discussed, to certain individuals that might need treatment for alcoholism, and people might go and use FMLA for treatment for drug use. But actively abusing illegal drugs does not constitute as protected activity under these laws. So typically where we see it is somebody tests positive for THC and then they say, well, I'm using marijuana for a disability, right? The disability is not being an addict. The disability in that case is typically back pain, mental health issues, things like that, that marijuana is assisting. Now the question is, what do you do next? Under the federal law and under Michigan law, the use of recreational marijuana does not immunize a private employer from enforcing its policies. But again, we would want to look at a situation with the disability and whether this requires accommodation and further conversation. So beyond pre-employment drug testing and sort of assessing these things. You know, when we look at alcohol, a lot of times there are issues with alcohol use because it's legal, just like recreational marijuana, although it's recreational marijuana, still have the complication with it being an illegal drug. Generally, when I have cases involving alcohol use, it's at functions or it's off work and then bleeds into work. So, you know, breathalyzing somebody that smells like they're drunk at work is not a medical examination. You know, if we're dealing with a specific circumstance, but saying, you know, we're going to test you for alcohol because we think you're an alcoholic without that objective basis to do it will be considered a medical examination. So if you're just randomly subjecting people to breathalyzers, you are conducting medical examinations under the ADA, and you need to make sure that you're really, really in a good spot to do that. And if you're doing random drug tests, well, it might not be a medical examination. We need to make sure that, you know, you're not doing it in a way that's going to affect retention and recruitment of employees. When you look at you know, how this all blends together, drug testing, ADA, I'm just trying to simplify this as much as I can, and I know we're running short on time. The long story short is that the ADA is not giving us very clear parameters. Do it then, don't do it here. This is the result. This is the level of THC. In my practice, drug tests is typically not a big problem for companies, so long as they have consistent policies. The question you all need to consider is, what do we do with THC? What do we do with impairment? And how do all these things blend together? With THC, I will tell you again, say you have a drug testing policy, you're not going to get rid of it, you're going to keep THC on the panel, and people are popping positive for THC. The next question I get almost always is, well, how much is too much, and is this impairment? So if we're drug testing somebody and they're positive for THC and we want to fire them under our policies, you know, if you have a zero tolerance policy, fine. If you're looking at impairment, that's going to be complicated. So the drug test is not going to tell you impairment. What you're really going to need to do is look at other factors, objective, you know, signs of usage, you know, whether you have video surveillance, whether there's an active smell, whether there were signals that he was portraying or she was portraying that lead you to believe there's impairment. Drug test just is not going to be very helpful in that regard. So moving on to our next slide. Again, I don't want to belabor this. I want to make sure we cover the Pregnant Worker Fairness Act. So just one thing I want to note, pre-employment inquiries about disabilities. Okay, so just keep that in mind if you're dealing with an ADA question. Where this will almost always come up is somebody mentions something in an interview or is asked something in an interview that leads to, well, can we follow up about, you know, what that means, how it manifests. The question you can ask is whether the individual can perform the essential functions of the job with or without a reasonable accommodation. You can ask that, but we have to be very conscientious of the fact that the ADA is going to prohibit employers from making pre-employment inquiries about disabilities. So please keep that in mind as we move forward through this process. And then you get to the question of, what about conditional job offers? Okay, pretty cut and dry here, because testing for alcohol, unless there's a legitimate reason to do so, is going to be considered, you know, a medical examination. We have to ensure that that's not occurring before there's a conditional job offer. But testing for illegal drugs, generally the way that we see this come up is you have to pass a drug test to get this job, and that's never been a real problem. All right, this slide is pretty self-explanatory. Again, I think that it's worthwhile to really sort of hint on some of the other concepts. So John, if you don't mind going to the next slide. And I would just, again, look at confidentiality and look at assessing pre, post, conditional, non-conditional, and what are you doing with THC. You have a lot of flexibility, and I am rewriting a ton of drug and alcohol policies right now because times are very different. And so the tests and the panels that were used 5-10 years ago are just often inapplicable. So please know that if you're in a position where you're struggling with this, we are happy to provide very specific advice, rewrite those policies, get them in place that you can feel confident moving forward and that everybody's aligned in terms of when we're testing, what for, and why. With that, I'll let Shanel close us out by talking about an important law that's getting a lot of scrutiny.
Yeah. So I'm going to be really quick here because I know we've hit time and I want to be respectful of everybody's, lunch hours or whatever you have. But I do very, very quickly want to touch on this because the Pregnant Workers Fairness Act, or what I will call the PWFA, is on the EEOC's strategic enforcement planning for the next 4 years. So they are giving this a lot of scrutiny and a lot of attention. And the long and short of it is that this act, Michigan also has its own act, but it mirrors the federal act. And it provides that reasonable accommodations for known limitations related to pregnancy, childbirth, or related medical conditions. So this act will apply to private employers that have at least 15 employees, as well as federal agencies, union, and employment agencies. It pretty much what you guys really need to know about this act is it really mirrors the ADA and the FMLA with a lot of things. The definition for reasonable accommodation is the same. Who's qualified under this act is the same. So what you really need to know is that it really just provides a broader protection for these individuals, because as you will see, I believe it's on the next slide, the ADA already has a protection that says that an individual must have a pregnancy-related disability to be entitled to an accommodation. And that's the difference between the laws that we already have in place and the PWFA. The PWFA does not require a full-blown and formalized with paperwork disability. It simply requires a known limitation. This person just has a limitation related to pregnancy, childbirth, or a similar medical condition. And as long as the employer knows about that limitation, it could be, just needing time. It could be someone who suffered a miscarriage and subsequently is in therapy related to that. If that is known and that's a limitation, they're required to an accommodation. So the FMLA is still in play here. The ADA is still in play here. The PWFA just gives these employees more protection. And then the last slide here, again, because the PWFA mirrors the ADA and the FMLA, the adverse actions and what employers are not allowed to do is pretty much exactly the same. As you can see here, you cannot deny a reasonable accommodation to these individuals absent an undue hardship, which, as we previously discussed, is very, very hard to prove. You cannot require that a qualified employee take or accept an accommodation that's less than any reasonable accommodation that's determined during the interactive process. So again, the interactive process is crucial here. You have to have these discussions. You have to find out what the limitation is, what the accommodation is that they're requesting, and then you have to examine and evaluate the reasonability of that accommodation before you suggest something less than that or other than that. Similarly, as we know, you can't deny an employment opportunity because a reasonable accommodation will be needed. You're leaving yourself wide open to litigation. And then you cannot require a qualified employee to take leave if another reasonable accommodation can be provided. So if you can simply give them breaks, or if you can provide something else that allows them to continue working, you can't just say, well, here, just take leave. You can't require them to take leave if there are any other reasonable accommodations that can be provided. And with that, this law is new. It just took effect in June. So we are expecting to see a lot of scrutiny around it. We're expecting to see likely a lot of litigation to come out of it. We have more information regarding it, but that's the long and short. And I'm sure I can speak for Courtney and myself when I say, if you would like more information regarding this, to please reach out to us.
Yes, absolutely. And we have some fact patterns in there just for you all to consider. We don't have to go through those today, but just some examples of where, we think that there are likely to be questions and concerns under the PWFA. So
Yeah.
with that, I'm happy to answer any questions or to address any concerns that any of our attendees may have.
Okay, we do have a couple questions, and I think Shanel is going to kind of lead that discussion. And just as a reminder, if you'd like to ask a question, just type it into the question window, and we can take it from there. Shanel, you want to take a crack at the first one?
Let's see. I
John, I hate to do this. I don't see the questions. John, can you read the questions and then we can target them?
Thank you.
Oh, sure, no problem. I thought you had it. What happens when employees have exhausted their FMLA leave and they need to go back out? Are you able to terminate?
Okay, I'll do this, and this is a very popular issue. It depends, okay? So I have this come up almost at least once a week, which is somebody exhausts all FMLA and then they say, well, I can only work 4 days a week, or I can only work this schedule, okay? So the question is whether they have an impairment and whether there is an accommodation that you are required to provide to enable them to perform the essential functions of the job. So where we typically have success, and by success I mean you can deny the accommodation without fear of a likely lawsuit, is for employees that want to be late like an hour or 2 hours every single day and that need unreliable attendance. So this is the flare-up situation. Now, for most jobs, we can say that regular, reliable attendance is an essential function of the job. If you have individuals that are working remotely that have very flexible schedules, then that's not going to be the case. But if I have Tom, my example, he's on intermittent FMLA and he exhausts all of it, and he's got very serious mental health conditions that qualify as a disability under the ADA, but he doesn't know when he can come to work. If he has a depressive spell, it could keep him out for 3 or 4 days. It's unpredictable, it's unreliable. Then we can likely look at it after we get the information from his treating provider that enables us to assess under the ADA and say, listen, this is not an accommodation that's allowing you to perform the essential function. This is something that is eliminating essential functions of the job. So you're not qualified to do it. So that's really the issue. So when you have that come up, always remember there are 2 different laws and there are 2 different legal analyses. So we need information contemporaneous with the new issue. FMLA is done, now we have ADA. Let's send out the ADA questionnaire. Let's get the specific information we need, and then let's make an individualized decision. So that's generally how it goes. And again, that's going to be typically with attendance issues, but it could also be things like lifting restrictions, all sorts of stuff that comes up. Make sure your job description is really solid in terms of the essential functions, because again, if you want to argue, listen, Tom, I can't have you coming and going as you please, and really working an unpredictable schedule, because you need to be here regularly and reliably. I want to see, why that's important on the job description. Is he working with others? Is he collaborating in meetings? Is he required to provide time-sensitive reports? Like, what's going on that makes it such that that's true? And that's what the EEOC is going to ask for too if there's a charge. So just some things to keep in mind as it relates to that factual scenario.
Okay, we have one more question, and it's a point of clarification. Did I hear correctly that if someone has missed work and is on the verge of termination, then they claim they need assistance for recovery, and you cannot can you not then terminate the person from their position? So
on the verge, that is the most important thing I heard in that question. If I have, again, I think poor Tom is getting just absolutely destroyed in these analyses, but if I have Tom and he's got 7 attendance points and at 10 it's termination, and he's gone for 4 days and nobody hears from Tom, nobody has any idea where he is, so he's over the attendance points, and I send an email and say, I am terminating Tom when he comes back, or we're sending this letter to Tom. The letter goes out, it's done, the decision has been made. And then Tom calls in and says, well, I want those last 3 days to be excused because I was having, a problem with a drug, or, I was engaged in a situation with my alcoholism, and, that was the issue. That it's not going to retroactively immunize that conduct. Now, let's say Tom has 7 attendance points and he comes forward and says, listen, I need to take the next week off because I've got to get myself into some treatment. Okay, I can feel myself, my alcoholism is really bad right now. I need treatment, I need leave. In that case, you have to look at two things. One, is this covered by the FMLA? Is he eligible for FMLA? Because if so, that could be FMLA protected. And in that case, you cannot count the attendance points against Tom. Or, is this something that we have to accommodate under the ADA because he's got a disability and he's requesting leave as an accommodation to enable him to return to work. So you are entitled to get the medical information that you need to make that determination and to ensure that that's actually a reasonable accommodation that's going to enable him to work as compared to immunizing past conduct. So is it moving forward, or are we looking to try to get something taken care of that has already happened and a decision has already been made?
Great, thank you. Okay, we are up against our time right now, so we are going to have to wrap it up. So what I would like to do at this point is just conclude by saying a couple quick closing remarks. We will be sending out upon conclusion a post-webinar survey. We always love your feedback, so we hope you take a second to fill that out. In particular, in that survey, any topics you'd like to see us cover in the future, let us know about that. Our webinar, as we mentioned at the front, is recording. We're going to have that posted hopefully later today. So if you'd like to re-examine any of the issues or pass this along to colleagues and friends, you can do that by visiting the event page on our website, PlunkettCooney.com. We mentioned also continuing education credits. Those certificates will be sent out to everybody, and if you don't need them, just disregard them. And you can see our providers that we're approved for here on screen. And last but not least, we hope all of you would like to check out our blog. Sophisticated Employer Blog is what it's called. A lot of great information there about all employment-related issues. So if you haven't subscribed, it's a simple email link. Add your email to that area you see on screen there, and you'll be notified every time new content is provided. So with that, we want, on behalf of Courtney and Shanel and all the members of our Labor and Employment Practice Group here at Plunkett Cooney, thanks so much for attending. I know we covered a lot. Hopefully you found it interesting and informative. And until we meet again, have a great rest of the day. Take care, everyone.